about corruption in the judiciary.
What the two have raised is indeed a concern for many members of the Law Society. They have said there are areas that they are of concern that we need to deal with. And I think even Ahmed Nasir has come out very clearly. Even from last year, there was a colloquium he was supposed to attend, and he also raised that was something he was going to come and talk about concerns of there being creeping corruption at the judiciary. And that is the challenge that he says he's had is, tabling what is the JSC doing. But you see, he's addressed it also at the JSC level, the correct channel in which we should be dealing with corruption. So I agree to the extent that what we need to fight corruption at the registries, at the judiciary, and also judicial officers that are corrupt. But what I don't agree is coming out to blanketly label and try and profile the judges as a general that they are corrupt, because that what does it mean for you and me who are coming before those same courts and seeking justice? What we want to do is we have to fight corruption jointly, collect evidence, table before the Judicial Service Commission, and ensure these corrupt officers are removed.
Well said, well understood.
Yes.
So have you summoned your two senior members to come and tell them this is what you ought to be doing? Because when they make public statements, when senior counsel, respected lawyers, go out and say there's corruption in the judiciary, not once, not twice, not 3 times Ahmed Nasir has said this. And yet, I'm not aware of a specific complaint that he has filed against an individual judge. Have you taken issue with that?
Ahmed Nasir actually said he has tabled complaints against certain judges and magistrates before the JSC before. So he's talking about something that he's actually taking action against. So we haven't summoned him, if that's what you're looking for, that answer. We haven't summoned him, but he's exercising his right of free speech.
Okay.
Why we are holding the president accountable? Because the office of the president carries a lot of weight. Ahmed Nasir is not the president of the Republic of Kenya. Nor is he sitting as the head of parliament. He's not the speaker of the National Assembly or Senate. He doesn't carry that national sway that we are talking about that the head of state does. The head of state has a responsibility to carry out his duties following the rule of law. He has to remember that utterances that he made, he came in by the vote of the majority of the people of Kenya, so to speak. And therefore, with that support that he has, the utterances that he makes can shift and sway how the people of Kenya look at this judiciary. He carries a lot of responsibility on his back. Ahmed Nasir has not vied for any political seat in terms of national politics. That he has, that he can change a whole constituency on how they are looking at that judiciary.
He can shift public perception.
But yes.
Because of also his political weight.
Of course.
Same weight, one would argue, that Raila Odinga carries.
Yes.
He's also made such several times.
And remember when Raila made the statements and they said, let's do a march to the Supreme Court and bring the people against the Supreme Court. He was advised against it, because what would it mean for the rule of law? Well, politically for your people, you win. But what would it mean for that arm of government? And he decided not to. But here...
He didn't stop making the statements.
He didn't stop, but he didn't make that move, which would have had a great impact. Now, what we see is, apart from the statements of the head of state, they have now gone ahead to effect their threat. The Finance and Planning Committee and the Housing Committee have moved on. They are carrying out the stakeholder engagement, and they are moving to the next process. So they are moving, and I had the sentiments that Farah Malim was making recently, that they're trying to imitate the UK parliamentary system, where they feel that they're supreme and you cannot stop. And we all know that the executive has majority in parliament. So these two arms of government are purporting to override the independence of the judiciary. So our system, our constitution is not like the UK system. We have checks and balances. They must abide by the court orders. The court has said stop. You ought to stop. You can't say we have stopped, now we are doing it differently, so that you think you're trying to circumvent the court order. That has to stop. So you see, the president has not only made utterances, but they have gone ahead with their threat and they are proceeding. And if you saw the recent statements that he made, he again profiled that these people are thieves, these people are corrupt, that you're stopping, these people are poor, they don't have homes. And you're touching the emotive part of the members of the country. Of course, everyone wants a house. Even you today, if you're told that you have an opportunity to get a home, and it's these judicial officers that are standing at your way, you've already profiled them. You've created them as an enemy to these members of the public. But that is not what the judiciary is doing. Due process must be followed. And that is what we want this country to be run on, the rule of law. So it's not what Ahmed Nasir has not made. He has made utterances, but has he gone ahead and done anything in abuse of any court orders? He hasn't.
What would the process look like, Faith? Because here we're talking about, because I think sometimes when we hear things like this, we gloss it over, sometimes, unless now, of course, going to go and say lawyers come out and protest against things like this. But it actually is serious when we talk about, again, an institution that forms the operations of government. It forms the character of government, and it carries agency when we are talking about how a country will be ruled. Now, if the executive has made utterances, it would appear as though he believes some of the things that he's saying when it comes to the recent statements. And you've said this several times, that if there is an issue, carry out the due process. What now would that process look like? If he said, look, I know of 1, 2, 3, and I would like to check on this thing. Of course, we know what this is all shrouded by. We know that the cases that are before, or the issues that are before the courts today, with housing and the, what's the other one? Universal health coverage, the social health insurance fund. We know those things are, and they're also front and center when it comes to the operations of government. But truly, if there is corruption in the judiciary, just as serious a thing, what would the process look like? If he said, we're going to actually deal with this thing like he has said, what should actually be done?
I want to give a recent case that happened, Justice Chitembo's case. And I think that one caught the view of many people in this country. The damning evidence that was collected by the then Governor Sonko, evidence that was tabled of matters that he handled in court. And what happened is that it was presented to the Judicial Service Commission. They sat, they found that he had a case to answer. Then the president set up a tribunal, which he also had representation. He had his lawyers. He was able to present his matter. The tribunal made a decision, presented to the president. The president agreed with the decision of the tribunal. He was removed from office, but he still had a right to appeal. He appealed to the Supreme Court. The Supreme Court upheld that decision. He's no longer a judge. Now, that is a simple case scenario of how it works. And I'm not saying that it's sometimes even easy to collect some of this evidence, because even as advocates, we get frustrated. And that's why I say, as also law society, we don't have space or room for corruption. We are not defending corrupt judges at any point. And also, we will be following up to deal with this issue of corruption and tabling it before the Judicial Service Commission. Because as well as lawyers, we have challenges of judges that are compromising cases. You feel, even just looking at a precursor of even magistrates handling matters that they don't even have jurisdiction on and making decision and proceeding thereafter. A lot of cases of evictions. You remember the one that was done in Westlands. And so some certain cases we agree there is corruption and we want to see action. And we will fight and push that some of these judicial officers cease to sit in those offices. Because indeed, if you look at some of the cases that are presented to Judicial Service Commission, some are quite painful, looking at what some of these judicial officers have done. And that is something that we're going to push for as a joint front. We at no point are supporting corruption, because a corrupt judiciary means that what judiciary for us is the last front that the citizens have. So if you cannot trust that this neutral arbiter can give you justice, then we go back to the streets. We lose the very basis on which our constitution is running on.
It's anarchy.
Exactly. So we agree in terms of Ahmed Nasir's calls and other seniors, even junior lawyers, we all agree as one, as law society, that we will fight corruption. We have no room for corruption. So we are giving even notice to all these judicial officers. If you're engaged in corruption, we will find you and we will ensure we deal with you, but in accordance with the law. That is what we're going to ensure, so that you will leave and there's no hope of return to that seat again.
One could argue that when the Vice President of the Law Society of Kenya goes on public media like this and says, you are corrupt judicial officers, we will find you and we'll hand you out of office. It's the same thing.
And not the same thing.
These are officers of the court threatening
no.
in front of whom they'll appear. What action has the Law Society of Kenya actually taken? You know, I'm just looking back in the last 20 years, 22 years, 20 years or so. We've had radical surgeries in the judiciary in the hopes that, we are bringing back sanity in the judiciary. We are weeding out bad apples in the judiciary. The Ringera team came up with a radical surgery. Judges were removed. Others opted even not to appeal their cases. They went home. Soon after, we have a new constitution, and the new constitution, one of the first things that it addresses is there might be bad apples still left in the judiciary. And one of the things that we must do is also go in and weed out, set up an entire vetting panel that went through all judges individually, all magistrates individually, removed some, retained some. Less than 10 years later, we are still talking about the same thing. What is this that's happening in the judiciary that would constantly bring us to this conversation? Every 10 years, we're having a conversation about bad apples in the judiciary and having to weed them out. If those that were left by Sharad Rao and team were clean, those that have been hired since then have gone through a proper public recruitment exercise, how would we be having bad apples in the judiciary? Only the walls in the judiciary is it the water in the judiciary? What is it?
I don't know if it's the water they take, but I would say that in every institution, you will find there are always challenges. I would say that even from the 12 apostles that Jesus chose, there was the one that betrayed him. So I would say that similarly, the way we have in the executive, we have ministers, we have cabinet secretaries and PSs that are corrupt. It's the same way we have corrupt judicial officers. And the reason that the Judicial Service Commission was set was to deal with these issues as a continuous, so that you don't have to wait for another radical surgery or another vetting board to deal with them. Now, you see, corruption is not just the cases of taking money for cases. Corruption also goes hand in hand with also frustrating and delaying matters. We have lazy judicial officers. We have also corruption even in getting court dates. And these are matters that we have been sitting and engaging in, not only bar benches that we have with the judges and magistrates, but also when we meet the Judicial Service Commission and even the Chief Justice herself. And, as much as I've seen also the vice president or the vice chair of the JSC coming out to talk about some of these things, she also needs to be seen at the forefront, coming out to talk about and what measures they're going to take. Because there is so much, even from advocates, apart from compromising of matters based and with the belief that people are collecting money, a lot of issues that are still arising is you cannot get court dates for your matters. And secondly, delaying on even granting justice. Justice delayed is justice denied. So if you sit on a matter for 2-3 years, or I come with an urgent matter and you hear it 6 months, 1 year down the line, that is not justice. So those are part and parcel of also the things that the Judicial Service Commission is supposed to deal and handle these complaints as a continuous process.
Have you taken specific cases to the Judicial Service Commission as Law Society of Kenya against specific judicial officers and said, based on how this judicial officer is conducting themselves in office, they are denying justice to the people. Have you taken such cases?
So within this last 2 years, we haven't taken cases. But what we are working on is a task force that will be able to handle. No, it's a task force run by the Law Society itself. So what we want to do is, because we have been able to collect complaints from different stations, we have 8 branches at the Law Society.
Madam Vice President.
Yes.
What powers does the Law Society have?
We can't table.
What powers do you have?
In terms of being able to deal with...
Can you licensure?
Can you disbar a lawyer?
What powers do you have?
You can be struck off. We have a disciplinary committee.
Okay.
But not for judges. We don't.
No. I'm not even going there. I'm just saying what powers you have, because all these people, even judges, are members of the Law Society. Am I right? No. Are they members of the Law Society?
They are members of the Law Society.
Okay, thank you. Now, the reason why I asked the question is this. Going in tandem with Eric's question, in the last 2 years, how many lawyers have you disbarred?
We issued a notice.
Okay, in the last 10 years, let's not put it in a tight spot. How many lawyers do you know of who have been removed from the role or from the register because of misdeeds?
I think we removed, the last time the CRJ published, there are about 40 lawyers.
How many lawyers are there in the country?
We are now running to 23,000.
Okay. Now, the reason why I ask, every time we talk about corruption in the judiciary, it is not possible for judges to be corrupt on their own.
Exactly.
Your members are part and parcel of the corruption, if indeed it does exist. The only problem is this. When we find judicial officers, judges, magistrates involved, their offices have gravitas. The effects of the decisions they make, if indeed they entertain and are part and parcel of the corruption, it is immense. That is the problem. But it isn't possible for it to be what it is, or it is alleged to be, without the participation of your members and you, learned friends. Now, if this then is the case, are there people, as we talk about corrupt judges, corrupt magistrates, lawyers who are known to collude with these people and who are part and parcel, whether as bagmen, because there are people whose job is to carry money, okay? Hiyo ndio hata inajulikana, huyu kazi yake ukitaka kwenda kwa fulani, yeye ndiye atakuelekeza kwa fulani, okay? Now, how do you deal with such cases?
City, you see, the thing about such an arrangement, it is a cartel. Unless the cartel, there is a whistleblower, who is going to table that evidence? How will you come across it to be able to deal with it? So unless someone within the deal was unhappy or someone is cheated, that's how the information now comes to the fore, and then we're able to deal with it. And for our lawyers, we take them through the same process, due process. We just don't disband our lawyers. There's a disciplinary committee. They're taken through due process. They present themselves, or they get an advocate to present them, and then is when a decision is made and they're disbarred. So the problem is, for such corrupt arrangements, the reason why cartels are difficult to find is, as long as the cartel is happy, no one gets to know how the cartel works or information on how to deal with that cartel. Now, you remember, even the videos that were shared by Sonko, there were allegations here and there about advocates being involved. But first of all, some of these advocates ended up being the witnesses. So you see the complication in that next. So how do you now take the person who says now they are the witness supporting the prosecution, and now us as LSK, we say we're coming to prosecute?
Madam VP, I am in a delightfully privileged position, because the things we speak of, I can claim ignorance. I'm not a legal officer. I do not go to court unless there's something that has happened that requires me to go there. But I have to marvel sometimes when you find senior members of your practice speaking knowledgeably and eloquently about corruption. I have to wonder, how do they know so much? How are they so knowledgeable about these things?
You know, the thing is, you hear these things, Siti Muga, but unless you have the evidence, it's quite difficult on how to nab it. And my worry is, even as the vice president, because I'm also a teacher of the law, is that when your students tell you, or now they are advocates, or they tell you, these are some of the challenges they go through or because you hear that your case was compromised, because this is the going rate for this person, this is the going rate. And I'm like, why can't you come and we file a complaint? But some of them are happy in the arrangement. They will not, because they are telling you it's either this way or there's no other way. So I'm telling them, let's sit and we find a way, then we deal with it wholesomely. Then even we have a private way in which we can try and set them up.
Madam VP, we have this situation in this country where our laws allows, you have to now guide me here. What sort of matters can we negotiate? Meaning there's something that seems to be wrong, or is there a threshold? Do I need to still say like 100 billion shillings before you can call me to negotiate? Or even if I steal 10,000 shillings, you can call me to negotiate? These settlements that we hear our law permits for people to negotiate, what are they?
No, the settlements that are done under the law are the ones that are done if we have a dispute and it's on, let's say, payment of, I broke your flask, it costs $1 million. We can settle if I only have 800, that one, and it's done in court also. Once we agree, that settlement is signed in court. So that one is above board, that's allowed. What is not agreed is you coming to compromise, sit with the judicial officer or find someone to approach the judicial officer
On your behalf.
on your behalf to agree that let's find favor for my client's case or give me these orders on behalf of my clients. Now that is not negotiation, that is corruption.
What I'm hearing you, Madam VP, saying is that even the Law Society acknowledges that there is corruption
Yes.
within the judiciary.
Yeah.
That the difficult part here is gathering the actual evidence that can sustain a case against a judicial officer or a lawyer.
Yeah.
Okay? Sounds the same thing that William Ruto has been saying.
Not exactly. Now,
That there's corruption in the judiciary. But
what we're saying, there are judicial officers that are corrupt. The judiciary is not corrupt. You see, you can have people in an institution.
there's corruption in the judiciary does not mean the judiciary is corrupt.
Yes, there are people in the judiciary who are corrupt. So we have judicial officers that are corrupt. You see, the problem we have is labeling. And as Citi said, once you start labeling, then you dehumanize and change the way people look at this arm of government, such that even when they will stand up and raise and fight against something that is wrong, it'll be harder for the citizens to come and rally behind them. Because remember, the courts are not like Parliament. Parliament can make press conferences. They can come and stand. They'll make laws and tell the president even go to hell if they deem so.
They seem fair.
But judiciary cannot come out to say such things. They can only speak through the pen.
What you're saying, Faith, do you honestly believe that what you've said today, in terms of, yes, we know there's frustration because there are some judicial officers who are corrupt, there are some officers within the institution of the judiciary who frustrate the case, who are lazy. You've said they're lazy judicial officers. Do you think that in the public, we think, okay, so the LSK is saying that there are some judicial officers who are corrupt, or is that the public is taking it as there's corruption in the judiciary?
Can I tag onto that just a little bit? Because here we are saying, and maybe even a scarier thought, that if there is the existence of corruption in the judiciary, what is being pointed out at from the president today is not that corruption in the judiciary. That it is the notion of corruption in the judiciary because particular rulings have not gone in the direction in which you would like them. For me, that's a scary thought, as opposed to dealing with this monster that could be corruption. Are we saying that it has come out in the manner it has come out because rulings have gone in a certain way?
I say exactly that. We see when certain rulings have now since come, because it was all praise and pomp, and it was a lovey-dovey relationship initially. But now that we are seeing the judiciary coming out and showing their teeth, I would say, now we have a situation where they're being labeled as corrupt, that the judiciary accused the judiciary corrupt because certain decisions are not aligning to what the government wants. You saw the finance bill. Once that decision was made, then comes the housing bill, then we have the health bill. And, you know, the executive may have good ideas, but it's just the way they are going around it. No one is saying, and I don't think the judiciary, by stopping them, is saying that these are not great ideas. These are not things that you can help the citizens. What we're just telling you is follow the rule of law. There's a process that you need to follow. There's a manner that things need to be done. And I want to say this before we finish. The quagmire that we have that you raise when you're saying that you're fearing that what this may bring is that the president is only raising this question because things are not going their way. The judiciary will only have 3 choices: to capitulate and give in to what the executive is saying. 2, to say they're not dealing with anything that touches on the executive until they say they will agree to court orders. Or 3, they continue reviewing court matters in accordance to the rule of law, but let us see the judiciary speak by the pen. We saw that happening with Mrema when he said that Kinoti would serve sentence for contempt of court even after his term is over, to show that you are not above the rule of law. We saw Professor Ngugi coming out to say that in the High Court at the BBI case, telling the head of state that you are not above the law. And that is something that has gone down, and they have spoken through the pen. Let us have our judiciary as well being brave and speaking through their pen. Let us not capitulate and lose this independent arm of government.
Well said. Faith Odhiambo, Vice President, Law Society of Kenya. More coming up in the next hour, 8 a.m.